Next, we'll jump over to branding, which is covered by trademarks. As it says there, source identification. And a trademark can be any name, symbol, design, scents, sounds, colors, or motion that is capable of distinguishing one's goods or services from that of another in the marketplace. And you'll hear the difference between trademark, service mark. Trademarks cover an actual good, a product. A service mark covers a service, legal services, physician services. They're fairly, the laws cover them pretty much the same, except one's covering a service and one's covering a goods. So when you're, the use and how you use it might change a little. Whereas a product would pretty much have to be marked with the product on it. A service has some more leeway sometimes because of you're a professional providing the service, so you're not going to have it labeled on you while you're doing that, although you can. It's going to probably be more of based on your website and how you use it in your office. Trademarks actually get registered. They could be registered both federally and with the state that you're working in. We generally, with most clients, because they are marketing or providing service in multiple states, it's better to go for federal trademark registration, because then it's as if you're using it in the whole country and you can block someone else in another part of the country from using that trademark. Also, there are foreign trademarks, which depending upon how worldwide your services are or where you're practicing, it might make sense to go for both a U.S. and a foreign trademark. In the U.S., something that's important to note is your trademark, you actually have to be using it. In your trademark service mark, you actually have to be using it in the U.S. in order to obtain a U.S. registration. There are ways to file what's called an intent to use application if you have a good faith basis that you're going to use a trademark. So if you come up with a great product line or a great service that you know you're going to start marketing, you might want to go ahead and file for the trademark beforehand to ensure that no one jumps ahead of you in priority or starts using it before you and obtains priority. This way you can file what's called an intent to use application. It's pretty much like a save to date. As I said before, they're registered federally. You can only use the R symbol once it's actually registered. However, you may use the TM for a trademark for a product or the SM next to it at any time. It's essentially just putting others on notice that you're claiming that as a service mark or a trademark. Examples of trademarks are the Nike swoosh, the NBC chimes, USP Brown, Invisalign. The O-Shot is another one that physicians recently, I think in the last couple of years, have branded and have turned into quite a valuable brand. And then there's, think of every pharmaceutical out there has a trademark registered brand name that they're protecting.